Hello, everyone. Good evening.
Good evening.
Good
Yeah, my
evening.
name is Hussein Mahadi. Please let's indicate if you can hear me loud and clear.
I can hear you.
I can hear you. Good
We
evening.
can hear you.
All right, thank you very much. Um, Hussein Mahadi, once again, the moderator for today's session. As you all know, today's topic is intellectual property registration, infringement, and enforcement. This is the week 3 of Jiipcc mentorship and internship program on IP. Welcome, everyone. So a quick one, I'll just be asking a few questions before we jump into the business for today. I can see our mentors are joining the call. So I'll just pick some of our mentees randomly and ask how has the program been so far for you. So I will start with Imalbong Brown.
Okay, good evening. Can you hear me?
Yes, we can hear you loud and clear.
Okay. So the program so far has been pretty nice. My group mates, I'm in group 2. My group mates are really nice to work with. Like they're easy to work with. Like they're not like stressful or argumentative. They're pretty helpful. And then Mr. Dennis, one of the moderators, has been extremely helpful to me also because I'm always asking him questions for clarification or information. He's always been very, very prompt and happy to help. So it's been very nice.
All right, thank you very much. I'll be taking another person before we just quickly wrap up. Or any volunteer can just come up. Okay, I can see Zainab Oderanti. Zainab, what would you rate the Jiipcc mentorship and internship program on a scale of 10? And how has it been for you so far? Do we have Zainab on the call? Zainab, I can see you smiling. Why are you not talking?
Yes.
Okay, yeah.
Good
Can hear you.
afternoon. Yes, I will rate Gypsy a 10 over 10 because it's been wonderful being in attendance to the
Okay.
internship and members. Yeah, it's nice to work with them.
All right. Thank you very much for that feedback. Mr. Dennis, please kindly confirm if our mentors are on the call. Okay, so
Not yet. We don't have any mentor on
is
the call.
unstable. I don't know if you can hear me now.
I can hear you, but you're breaking up
Can you hear me?
Yes, I can hear you.
All right, thank you very much. Okay, why?
Yes.
Okay.
Respect on that.
Okay, Mr. Dennis, can you please stop sharing your screen so I'll be able to share our mentors' profile screen? Quickly read them through. Okay, we have 6 mentors today, and their profile is very lengthy, so I'll just, because of the time constraint, I'll just see how I can just summarize, just read a few paragraphs from their profile so we can start the program proper. Okay, I can share my screen now. So can we see my screen?
Yes, we can see.
All right. Our first mentor for today, as you can see on the screen, is Rita Anwiri Chinda. And Rita Anwiri Chinda is a distinguished lecturer at Rivers University and an expert in intellectual property consulting. She currently serves as an IP consultant for IGA Nigeria Limited, providing valuable guidance on commercializing and monetizing Lagos State's culture, tourism, and heritage. In her role as a heritage consultant for the Lagos State government, she offers legal advice on leveraging the state's intangible assets. Quickly, the last paragraph of our page also. An adept public speaker and educator, Rita has spoken at many events, both physically and virtually, to raise awareness and educate students. co-workers, creative innovators, and sectors that interact with intellectual property. She enjoys traveling, watching South Korean K-drama films and television show, listening to music, and she adores dogs. So that's our first mentor for today, Rita and Wiri Chinda. Our second mentor for today is Miss Amosa Shukrat Modupeola. Shukrat is a seasoned intellectual property consultant, analyst, and educator with a public sector experience. She holds a master's degree in intellectual property from the prestigious African University Zimbabwe in collaboration with WIPO and the Japan government. And Shukrat is an accredited agent at Intellectual Property Office in Nigeria and the pioneer of the Intangible Nugget, an educational platform which is responsible for fostering, among other things, intellectual property advocacy, awareness, and education. You can all follow both mentors I've introduced so far on their social media platforms. Our third mentor for today is Mr. San Mbakalu. San Mbakalu has over 15 years experience implementing international development programs in geographical indication, international trade and investments, trade policy, research, policy reform, market access, monitoring and evaluation, capacity building, market linkage, and value chain. San's experience is cross-cutting in a complex cultural environment, applying multidimensional techniques and entrepreneurial capacity to deliver results. He is the lead technical consultant on African intellectual property and innovation, AfriPI project, and the EU IPO founded and funded programs supporting the Nigerian government to create enabling environment to project and promote geographical indication in Nigeria. San is also leading the national research project funded by the France Development Agency to identify potential geographical indications products in Nigeria. That's just a quick summary of Mr. San Mbaskalu's profile. Our fourth mentor, is it the fourth? Fourth mentor for today is Mr. Max Ikongwe. Okay, I will just inform that we have two mentors on the call, Miss Rita and Miss Amosa. Welcome. Welcome, and also I can see Mr. Sand. I don't know if Mr. Sand is also on the call yet. So quickly, I'll just be reading his profile. Mr. Max Ikongwe is the founder principal of Everlaw Associates. He works extensively in the field of arbitration, ICT technology law, and intellectual property. Max is a facilitator on the annual Information Technology and Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He's trained in Advanced Intellectual Property Law course at the World Intellectual Property Organization Academy, WIPO Academy, and he is an accredited agent of the Nigerian Trademark and Patent Registry, and he conducted IP registration business there since 2010. Our fifth mentor for today is Mr. Folariwa Aluko. Folariwa Aluko is a legal practitioner and partner in the firm of Truman Rockwood Solicitors, where he provides advisory and consultancy service to companies and a wide range of creators, users, and startups. Welcome to the call, Mr. Max. Folariwa is a consulting mediator with commercial intermediates and ADR firm based in Lagos and Abuja. He is a thought leader in Nigerian innovations, technology, intellectual property, and entertainment space. As our fifth mentor for today, and our last but not least mentor for today is Miss Nirvana Talk. She is an entrepreneur, intellectual property rights and affair executive, offering 26 plus years of law, firm, and in-house corporate experience combined. Instrumental in mitigating risks, building organizational capacity, driving optimization, and securing multi-million-dollar deals. Experience in partnering closely with C-level executives on a wide range of legal, compliance, operational, finance, employment, and strategic business matters. Enterprise in licensing, acquiring and enforcing intellectual property rights related to platform leveraging business acumen and legal expertise to drive growth while resolving complex issues within high energy and fast-paced environments. We represented clients in commercial litigation, transactions, and intellectual property matters across a wide range of industries in the Gulf nations. These are all our mentors for today, and we look forward to learning a lot from them. Without further ado, I'll be calling on our mentors on the call now. I'll start with Ms. Shukrat Amosa. If she's available, she can take the floor. Kindly know that you have 10 minutes to talk on the topic. As we all know, the topic for today is intellectual property registration, infringement, and enforcement. Thank you very much. Do you have Ms. Shukrat Amosa on the call? Can you hear me, please? Let's indicate. I've just been talking and I've not been asking.
Yes, we can hear you.
I hear you.
Yes, I can hear you.
All right, let's have Ms. Shukrat. Okay, Ms. Shukrat is now coming up, so I will just call on the second mentor, Ms. Rita. Ms. Rita, if you're on the call, please, the floor is yours.
Okay, hi everyone. Good evening. So I'd like to say thank you to you guys for bringing me back again. I'm going to be very brief with my presentation. I hope so. So talking about IP registration, IP infringements, and enforcement. The first thing that we need to understand is that all of these three things are connected, because without an IP registration, there will not be a need for you talking about an infringement and also talking about enforcing your rights anywhere. So for IP registration, you need to consider the type of IP in question. IPs like copyright do not require any kind of formality. However, depending on your jurisdiction, can you guys hear me? Because I'm actually on the road.
Yes, we can hear you, ma.
Yes, we
hear you
can.
loud and clear.
Okay, great. So for IPs such as copyright, which grants automatic protection for the moment the work is created, there's no formality. However, some jurisdictions require mandatory registration, such as the US, or the applied depository IP system, like we do here in Nigeria. If you read the copyright law, it provides that a copyright owner may register a work with a copyright commission. So in the event of a dispute, you might have to use it as your documentary evidence when you need to. Whereas for other IPs like trademark, patent, design, you're required to register these IPs so that you can enjoy legal backing. You also need to consider the criteria. What is that thing that makes a work to be classified as a copyright or as a patent or as a trademark or an industrial design or any other kind of IP, such as the common ones like the GIs, TKs, the GRs, and the rest of them. You also need to consider copyright that exists, but another one IP may decide to explore two or more IP to protect yourself. So you're not leaving rooms for any kind of to take advantage of, which you want to register the work, whether it's going to be a national registration in the country you're based in, or a regional registration, such as the African, the ARIFO, or the OAPI, or the Euro, and the rest of them, or you consider international instrument whose sole objective is that every member state should receive protection and recognition for their creation and invention, which is also regarded as national treatment within the international space. Then we move on to IP infringement. We already know that an infringement is an act done without the express and exclusive Yes, fine. Without the express and exclusive consent or permission of the IP owner. This can be determined by the subject matter in question or the jurisdiction requirement for what qualifies as an infringement of an IP, whether it's a copyright, trademark, patent, or design. You also need to consider if the infringement was born out of a contractual obligation. You can also look at the applicable laws when such dispute arises. What are the available remedies? Is it going to be a civil remedy or a criminal remedy? And then because we're going to be moving on to the enforcement, and we also need to consider the enforcement, whether it's going to be a national judgment or recognition of a formal judgment, especially in regards to ADR proceedings or even litigation proceedings in relation to cross-border infringement. Then there's the question to the fate of unregistered filing or suing the person for passing off. There's also unregistered design right. We do not have an express position for unregistered design right. However, what the Patent and Design Act provides is that you have 6 months to regularize if you've done a publication of that design in question. Then there's conversation as to dispute in relation to or infringement in relation to cultural appropriation, where someone takes advantage of a particular location or indigenous work and decide to create a product out of it. I think we've seen a couple of luxury brands who have been accused of that. Then you also need to consider other uncommon form of IP. Uncommon is like my own classification anyways. So uncommon form of IP within Nigeria and within the African region would be geographical indication, traditional knowledge, genetic resources, and all of that. I'm sure we are aware of the new WIPO treaty that protects this kind of IP that makes a requirement for transparency as the original AI infringement with all its peculiarities. We've not seen AI dispute being commenced in Nigeria, but in other jurisdictions, especially within the US and the EU, there are lots of AI related dispute. I think yesterday or 2 nights ago, I saw a post online about an artist. Okay, I'll share that later. About an artist who had used AI to commit streaming fraud. He was recently indicted. So I'll also share a link to that later on. But moving on to the last form of the conversation we're having today, which is IP enforcement. This basically stems from the mode of dispute resolution mechanism that can be used when a dispute arises. This will include a cease and desist letter or takedown proceedings or the use of custom to fight counterfeit and piracy or trademark opposition in the event of similarities in the name or a trademark application being done by an applicant or a proprietor or the agent in question. They also have option of filing a lawsuit at the Federal High Court for Nigeria. If you're from another jurisdiction, you might want to find out the court that has the jurisdiction to hear IP-related matters. Jurisdictions like the US have small claims court to resolve IP-related disputes. We don't have that yet in Nigeria, but we're hoping that that's going to be done someday. And then there is exploring mediation or negotiation or arbitration or hybrid. Arbitration, like I tell people, is mostly for huge commercial transactions. So you're going to be considering like a technology transfer dispute or a licensing dispute or a franchise dispute. All of these are the available, what I call them, ammunitions that an IP owner can explore within their territory and also regionally or internationally. You can also check out the WIPO mediation and arbitration proceedings. I think they have like a directory of cases. So I guess my 10 minutes is up, but I'm available for questions And just to conclude that in all of this conversation, there's a need to consider public interest in relation to IP and also balancing the rights of the IP owners and the users in question. The IP community strives to uphold these principles. And finally, there's a need for us to set like an African standard in all of this conversation in relation to IP registration, IP infringement, and enforcement. Thank you, guys.
Right. Thank you very much, Ms. Rita, for that summary of the topic for today, informing us that the whole other parts of the topic would not be enforceable if IP is not registered, how they are all interconnected, and how they are all different in different jurisdictions and countries. So I'll be calling our next mentor for today. I can see Mr. Max is on the call. Mr. Max, please, it's over to you. Do you have Mr. Max on the call? Mr. Max Ikongwe. Okay, while we are waiting for Mr. Max to set up his settings to join the call, I'll quickly call on Ms. Nirvana Talk to also take on the topic.
Hello, everyone. I'm really a pleasure to meet you today and to discuss concerning the IP infringement and the IP enforcement also, because it's very interesting subject and topics that we have to discuss. Okay, just a minute. Just a minute because the connection, yeah. You know that I have already make a study in Africa, North Africa and these countries, and many countries in Africa. I'm so interesting to make these studies concerning especially the IP enforcement, yeah. Because already I have experience in IP law firms in the UAE and Morocco. And through this experience, I realized that there is many infringement, especially in the e-commerce. The last, let's say 7-8 years ago, there is many infringement and on the protection of intellectual property and the e-commerce platforms in Africa and the Arab countries also, yeah. But as we discussed as African, we should be aware about this and how to protect our commerce, our contracts, our business as a whole in our African countries against this infringement. Because there is many hackers and digital, how to say, digital problems and infringements that happened all the time. Also, there is many infringement on bank account also that I already faced. I have a real case, okay, that I faced maybe 2 years ago in the UAE. And there is a hacker on my credit card that stole all my amount of money. Especially it was credit card, so it was a big problem that they the money is not already on the account. As you know, the credit card, it is on the deposit. So I have to want to pay this money after that to the bank with interest on many months on installments. So it was high costly for me, yeah, because the bank take interest. And unfortunately, when I went to the police and discussed with people related to all these hackers and online money stolen and all of this, they try to help me, but there is no actually there is no effective resolution, you know. So from this life stories that I faced, it wasn't easy at all for me at the time. I advise you to take care about this, that we should, as the countries, we should make and put regulations from our legal and how to say, regulations background, and through the regulation in our countries that we should develop to be aligned with this new infringement happen in our countries. We should also update our legal regulations and notice. And as a paralegal, I work with many lawyers, so I discuss this with lawyers and advocates concerning these points, that we should focus more in our area and our modern life, concerning the digital infringement and the installment on banks, on intellectual property protection, on our documents, also data protection, because this case concerning the bank, it's related to the data protection, which is very important, and technology. So we should upgrade these regulations related to data protection, data information, personal data, especially related to the person, to his business, to his tasks, to his assets, for example, and responsibilities related to these assets. Also, we should also update, it's very important, also the contract itself, the agreement of dealing concerning business, concerning franchising, for example, and licensing. So we take the protection needed as much as we can to confront this infringement against our contracts, our legal how to say, our legal steps that we should review and how to say, to revise more these important contracts and agreements related to this intellectual property rights or our business as a whole, in order not to face and to have other infringement, other installment, other problems, or how to say, it's like it's not an easy problem. It's a big loss. Yeah, we lose a lot of money, a lot of how to say, our name in our brand in the market also. Yeah, so this is very important to protect this. So this is my advice, that we should all the time update. I already participated in many webinars concerning the blockchain, which will be more from my point of view and other people, that will be more protection for the contracts, especially which related to copyright, especially, and related rights. This kind of blockchain contract will be more protected because it's divided by blocks, and it's completely protected by many passwords, many passcodes, and all of this. So it will not be easy, until now, for hackers to know, or to discover, to know the secret code applied here. And there is a lot of complicated also passcodes, not only one, and there is many steps that should be taken inside this blockchain. So I think this is a good way to face this infringement, especially in the intellectual property rights. Thank you.
Thank you, ma'am.
All right, thank you very much, Ms. Nirvana Talk. Very, very sorry for the loss you had from the hackers, and also thank you very much for sharing the story to every mentee and also other mentors on the call.
Yeah.
Also,
Most of the time, I try to advise people to take care about this in every place in the world because it's not,
right.
you know.
Thank you very much for also hammering on data protection and also recommending blockchain technology. So all our mentees and mentors out there, let's be careful with our data and let's make sure to protect ourselves with different layers of password at every aspect of our business and endeavor. So I'll be calling on our next mentor quickly. Okay, before I do that, the weather at some place is getting dark now, so I will encourage everyone to turn on their videos. Let's quickly do the normal thing, our usual tradition of turning on our videos, smiling for the camera, and taking beautiful and lovely pictures for our social media posts. All right, I can see so many of us have turned on our videos. Thank you very much, everyone, for turning on your videos. Quickly, I'll be taking screenshots. Let's smile for the camera. Okay, thank you very much. Some of us are using so many beautiful toothpaste. I would ask, please, you guys should recommend nice toothpaste for white teeth for me, so that I would also join you guys in that very white shiny teeth journey. Okay. Taking a few screenshots. Mr. Dennis, I hope you have also done the same.
Yes, I have.
All right, thank you. Okay, moving on to our next mentor, Mr. Max. I can see Mr. Max Ikombe is also looking Friday-ish like me. Thank you very much for rocking our national attire. You can see me today, I'm a Yoruba man. Today, Mr. Max is an Hausa man. So thank you very much, Mr. Max. It's over to you now. Our topic for today is intellectual property registration, infringement, and enforcement.
Thank you very much, Hussein. It's really good to see you. I hope you can hear me.
Yes, we can hear you loud and clear. Yes.
Okay. Thank you so much, Hussein. Good to see you again. I've not seen you in a while. It's good to see you again. And let me just acknowledge the mentors that have gone before me, and to also let the mentees know you guys are in a lot of a good spot. You actually brought my mentor of life, Rita, today. So it's a delight to be following after her. And of course, always good to hear Nirvana give us a very broad and international perspective to IP. So as usual, I'll keep my remarks short and just try to give a few pointers about practical tips on IP registration, infringement, and enforcement. So the first practical tip I want to give is that as a professional starting off your career in the IP space, one of the first opportunities you have will be registration. That's about the easiest kind of instructions you will get, quickly. But just to let you know that registration purely itself, in terms of the administrative processes of registering IP internationally and according to best practice, not necessarily the work of an IP consultant or an IP lawyer. A lot of organizations and firms that do IP registration have a cadre of staff typically not lawyers who handle that aspect of the work. As an IP consultant, your work usually goes a lot beyond merely registration and doing the administrative processes of registration. So things like advisory, strategy, and all of that is kind of a lot more of the work that you're expected to do as an IP consultant. I say this because I see a lot of people start their IP career and they get stuck in doing registrations only. And while it's not bad, but I'm just saying that it's not the optimum use of your knowledge and your time as an IP professional. You should go beyond the range of registration, even though it's the easiest place to start, but do not stop there. Move on to the other parts of the IP food chain, which will include talking about infringement and enforcement. So going to infringement, I also want to point out that from a practical point of view, you need to understand that IP infringement is not, it's a complex issue. So not every infringement is applicable to every type of IP. So taking copyright, for instance, what could be infringement of a literary work? Of course, by now we all know that copyright has 6 categories of works protected: literary works, musical works, sound recordings, artistic works, broadcast, and audiovisual works. Those are the 6 categories of works protected by copyright. But what you need to understand is that not every action of infringement applies to all 6 of them. So for instance, with broadcast right, what would amount to infringement of a broadcast right is not exactly the same as what amounts to infringement of a literary work. You need to understand those differences. And if you are having to advise a client or to bring an action for infringement, you need to categorize very clearly what the infringing act is. I'm saying this from a practical viewpoint because I've seen a couple of people plead or file their pleadings in court, and they have not given very good expression to the infringement that they are claiming. So you need to be careful and know and understand what exactly is an infringement in every context and plead it properly. And same goes also for trademarks, for patents, and for designs as well. You must understand what an infringing act is and plead it properly. And then speaking on the last, which is on the enforcement. Of course, enforcement is a broad range of things. Rita already gave us an idea of what enforcement covers. I will focus on litigation. So if you are trying to enforce your client's IP right that has been infringed by way of litigation, you need to also be careful. Because, of course, anybody who is a lawyer in Nigeria understands that the issue of jurisdiction is a very hot topic in Nigeria. That so far as Nigerian law is concerned, even if you have a good case and you go to the wrong court, you will end up losing that case. And sometimes it's painful because you are not losing the case even at the first instance. So if you have gone to the trial court, you won the case. You went to the first level of appeal court, into the court of appeal, you won the case. And for the first time, your opponent goes to the Supreme Court and raises the question of jurisdiction. And on that point alone, without looking at the substance of the case, you will end up losing the case. And you have to be sent back to start the case all over again. And of course, by that time, maybe 10, 15, 20 years have passed, your client has lost interest. So understanding the court that has jurisdiction for your IP case is extremely important. That's the first point. The second point is that we all know, if you have studied the Nigerian Constitution, that the Nigerian Constitution clearly specifies what matters are federal matters that are taken up at the Federal High Court, what matters are state matters that you can take up at the State High Court and the High Court of the FCT, for instance. So understanding that distinction is important. I say this because a lot of people have the assumption that intellectual property is a federal matter and can only be litigated at the Federal High Court. Now, that is somewhat correct, but not exactly correct. The way the Constitution splits it up, if you look at the Constitution carefully and the list that lists out what is a federal matter and what is a state matter, it doesn't mention the word IP. It mentions types of IP. So copyright, trademark, patents, and designs are mentioned. And I mentioned this because when Rita was speaking, she told us about other forms of IP. So for instance, geographical indication, for instance, is a type of IP, but not mentioned in the Constitution. So if we had a proper geographical indication law in Nigeria and we were to bring up a claim for geographical indications, you would not be going to the Federal High Court. So it's better to understand that. Now, other forms of IP, passing law, for instance, and trade secret, you cannot take that to the Federal High Court. They have to go to the State High Court because they are not listed as one of the matters that is exclusive to the Federal High Court. However, more often than not, a claim in passing off trade secrets and all will be allied to a claim in trademark or a claim in patent. So if your principal claim is trademark, patent, copyright, or industrial design, and the secondary claim is passing off or any of the other types of IP, then you should also be able to take out that claim at the Federal High Court. So it's a dicey issue that needs a lot of thought, a lot of careful thinking about, otherwise you end up in the wrong court and you end up losing your case. So I just thought to put out these few practical points, and of course, when we get to the question and answer segment, we'll discuss some more. Thank you, and back to you, Hussein.
All right, Mr. Marks, thank you very much for giving us that very practical view of the topic for today. Few recaps that really caught me, going beyond just IP registration, understanding infringement in every context, and also understanding the court that has jurisdiction on any of your IP infringements. Thank you very much. I think we have some questions on the chat box, but we'll just leave that for the question and answer session. Okay, as per a mentor's request, we'll take on our pictures again, just for one more time. One of our mentors was not caught on the last picture session, so let's just do that immediately before we move on. Thank you very much. Please kindly turn on your videos and shine your 32. Very demure. Artists are looking shiny. Thank you very much, everyone, for turning on a video. All right, one more time. Let's wait, please. I've not seen the mentor on the call yet. Miss Nirvana, please. Okay, I can see her now. All right. Yeah, that's nice. Okay, we can move on now. I'll be calling on the first mentor I called. She was not on the call. Miss Amosa Shukrat Modupe Ola, to take on the floor. Please note you have 2 minutes to talk on the topic, IP registration, management, and enforcement. Yes, we can hear you, ma.
Okay, Mr. Ozen, good afternoon. How are you doing? It's been a while.
Fine.
It's good to have you back on the call.
All right, thank you very much, ma.
I think the mentors have done justice, actually. When we have people like Mr. Max, Rita, Nirvana, they've done justice. I'm just going to probably give my part. And we're talking about IP registration, infringement, and enforcement. So there's a saying that what the law has joined together, let no infringer put asunder. So basically, before we start, let's just kind of do an overview of intellectual property. The first thing, it always starts with an idea. And idea will always come, be it a stupid idea or a beautiful one. There will always be an idea. But it's the expression of this idea that actually matters. So what happens when you have an idea? It could be a stupid one, it could be a beautiful one. But the first thing you have to do is you have to create this idea. By creating it is probably expressing it, probably in paper. It's an invention, you probably do an MVP, and so on and so forth. Then going forward, you find a way to probably register it. It could be an unregistered right, and it could be a registered right. Unregistered rights like trade secrets, you don't have to register that. Registered right like trademark, patent, it could be either of that. And once you get to that point, what do you do next? Because most people just seem like stop at registration and they don't go forward to the other aspects, which has to do with the policing. You have to police your right, because truly, as an IP rights holder, should I say you kind of want people to infringe so that you're able to make money from that infringement, because not everybody will come to you. And when they don't come to you to probably get a license to use your work, when they're not infringing on it either, you might not be able to make as much as you are meant to. So just like Barrister Kachi said in, I think, the previous classes, sometimes infringements are like, they come in form of blessing. right? Because when someone infringes on your rights, then it could be knowingly and it could be unknowingly. So before you go to court, you probably will find a way to, settle out of court and kind of get an agreement to probably license the right. And that way you're also making money. So that's where the policing comes in. So when you police, then the next thing you have to do is you have to enforce your rights, which Rita talked about very well. Then the lastly is the monetization. So by enforcing your rights one way or the other, you might be also able to, monetize that right. So what right are we talking about? We have copyright, patent, trademark, industrial design, and trade secrets. So it's one thing to understand the system, how the system works, because in Nigeria, we operate the first to file system and not the first to use system. So as an IP, let's say consultant or IP enthusiast, you need to understand the intricacies of most of these laws and how they work. So we Nigeria operate a first to file system as opposed to a first to use system. So even if someone is using your rights and probably you've not, let's say a trademark, and you've not registered it, and somebody else goes ahead to register it, the law gives that person upper hand because we operate a first to file system. It doesn't mean you can't oppose it. You can, but it's going to be stressful compared to you just going to register your rights before somebody else starts using it. Also, when you look at the national route, so let's talk about the registration aspects. What are the routes for registration? We have the national route, we have the regional route, and we have the international route. I think I went through one of the materials and they are kind of repeating the regional route. So I just thought to address it. So the national route is when you file in a particular jurisdiction. Say you have a business in Nigeria, and you want to protect your business in Nigeria. You file nationally in Nigeria. You have a business in the UK and you want to protect your mark in the UK. You file nationally there. So when you're filing in each individual country, that's national filing. So instead of you going to each country or getting an agent to file for you in each country, there's an option of a regional route. So a regional route is like it covers a particular region. For example, ARIPO. ARIPO is the Africa Regional Intellectual Property Organization. It covers most of the African countries, English-speaking African countries. But unfortunately, there are some African countries that are not members of that regional route. So because of that, you can't operate using that regional route. We also have EU-IPU. We have ARIPO, OAPI, and so on and so forth. Then we also have the international route. Say you want to file, you have business in so many countries and you want to protect your IP rights in many countries. It won't be advisable for you to get an IP agent in each of these countries to file for you. So what option do you have? You have the option of going through the international route, whereby you just pay one set of fee, fill a set of three, just one form, and designate the countries you want to file your application in. So once you get to that national phase, the application will be sent to each country. But this doesn't mean that if country A accepts, it doesn't mean country B will accept. So at that national level, it's dependent on each country to determine if your application meets up with their laws and so on and so forth. So these are the filing routes. And it also goes to say that, talk about the strategy you need to put in place. Just like Mr. Marks explained, what strategy exactly are you putting in place? Have you filed earlier? Are you trying to claim priority? Are you using grace periods? Probably let's say a patent, you launched your product during an exhibition and you haven't protected it. How can you use grace period to protect yourself and still file even after you've disclosed? So all of these things are the kind of IP strategy to put in place whenever you are looking into protecting your IP. So let's look into enforcement. So with respect to enforcement, let's look at infringement actually. So infringement is when you use something without authorization. That's an IP right. If an IP is not protected, in most cases, it's not usually called infringement. Say for trademark. If your trademark has not been registered, you can't say somebody is infringing. You are likely to say somebody is actually passing off because you haven't registered that right. So your enforcement refers to the act of putting measures in place against the use of your intellectual property rights without authorization. So there has to be an IP right before you can say, oh, somebody has infringed on your rights. So now, how do you enforce? What measures can you take to enforce? I know Rita has already spoken loudly on that. What I've noticed is, number one, most people don't even know what right was infringed in the first place. And they just say, oh, you've infringed on my rights. When you ask, okay, what exactly is the right that was infringed? They don't know. So you realize that by the time you break down or do an analysis of it, you see that, in fact, there is no even rights in the first place. Probably they don't even have registration of any rights, and you say someone has infringed on your rights. So there was this particular Instagram post. Someone was trying to bash someone that he was using somebody's work without authorization. Meanwhile, the person also copied somebody's work. So imagine the person that are trying to save is also an infringer. Do you understand? So most people don't even understand that, oh, you are actually infringing on somebody's rights by doing a particular act. So the first thing is you want to consult an IP consultant to be sure if your right has actually been infringed. If it has, probably you get a lawyer to draft a cease and desist letter for you and send to the infringer. Like I said, sometimes people don't infringe because they actually want to. They do because they don't know that it's an infringement, right? And by doing so, some people are going to comply and say, oh, I don't know. So what can I do? What do you want me to do? That way you can talk about licensing or royalty and so on and so forth. But some people are very adamant. They have strong head. They will not listen. So people like this, you go a step further. And how do you do this? You can either do arbitration, mediation, or you probably do litigation. And for social media, actually, you can report handles. There are takedown orders on social media like Instagram, Facebook, especially YouTube. YouTube is very strong on infringement cases. So otherwise, you can settle out of court. These are some of the proceedings you can actually use with respect to enforcing your rights. So I think I'll allow the the members to present, and so we can take questions. Thank you.
Thank you very much, Ms. Amosa Shukurat, for touching briefly on all the subtopics on the subject of today, and also giving us few examples. I saw Mr. San. Okay, I can see Mr. San Umba Palu is on the call, so we'll be giving him his own portion of the time to talk on the topic. Welcome, Mr. Sand. Thank you very much for joining us today.
Good evening, everyone. Apology, I might not be able to turn my camera on. I think it's best that I speak because of my current location, as it were. So I think the perspective I would come in from, I think most of the mentors have spoken extensively on the aspect of registration, infringement, enforcement. I think I will just make an overview statement in terms of where does an IP come from, and from an African perspective. So from the African perspective itself, for example, someone went to a tailor, and I think it was Rita that run a series on that. Someone went to a tailor, I don't know if she mentioned it, and asked someone to make a design for her and paid. And after the call, after the design she has finished making design for her wedding, and she saw that person wearing it, and she said, oh, why would I pay so much for you to also give it to some other person? So the issue is, who owns the right in the first place? Is it at every point in time that we want to run to the regulatory authority to raise an IP right? Something we presume to be an IP right. Who had the idea? Even if you have the idea, you went to meet a tailor to design something for you. Do you have a dotted line? They say, okay, this thing I've given you, don't share with anybody. But in the African context itself, intellectual property, and I've said this thing severally, and sometimes when I talk about it, people say it's a private right. No, in African context itself, intellectual property, it is not just a private right, it's a communal right, and we must see it from that perspective to also be able to appreciate. And I think the last session we had, one of the mentors spoke extensively in that aspect, and the aspect she was coming. I think Shukrat also mentioned it, that sometimes infringement can be for good. So when I talked about intellectual property, is it a communal right or individual right? Let's start from the registration. When you have an idea, it's an idea. It can either make, because when you have an idea, you register it. There are other things that goes with it, maybe the branding, the marketing, the publicity gets you the money, not because you registered an IP right that gives you the money. And I'm saying this as a business person, not as a lawyer. And we must differentiate it. Lawyers, and I know that this call is mostly made up of lawyers. Yours is to bring this money, let's register it. You're not looking at it from the perspective, would this thing even bring money to this person? But as a business person, the person must also understand that this thing will bring money initially. And it's also, okay, so there is the thin line between, do I register an idea immediately it comes, or do I start trading with it and register it as I start making money? Let it be my brand identity. It's a thin line. It's a thin line because you must look at the numbers for you to move and register, because you lawyers are not cheap. That's not a fact. The problem of IP with all of them when I know Kimi is lawyers. Because you make the thing so expensive, or because it's never not lawyers are registered, because as Mas has always said, is that sometimes you must not be a lawyer to register. So, but in a place of registering as a business person, I think where you should start from is, let me trade with this brand and consistently trade with this brand for a year and see what the number is. If it start bringing you money, you realize that is a proof of concept. The next stage is to go and register. However, you can assume, so this thing will bring and go by faith that we all do and go and register. And when you register, you must also do the needful for it to start trading. So now, registration is important. Who are the people that register nationally? With the government. So government regionally helps us to be able to file in one country. At the regional level, it spreads across other countries. Multilateral system, which of course, lawyers are against multilateral system to a large extent, because they say in the African context, Africa cannot reciprocate in the multilateral system. So that means those big brands that would have come to a country to register domestically, because its jurisdiction in nature will not do that. So we don't have business. So they encourage their national government not to participate in multilateral system. But as a business person, business people want to register, want their government to be part of multilateral system. So the government looks at it. Who do we go for? So most times business people are not always organized to be able to lobby or to facilitate or advocate government to participate in multilateral. So lawyers are good at this, because lawyers are economists, lawyers are they're almost everywhere. So they can speak to themselves and say, okay, don't be part of this agreement. Madrid Treaty, a case in hand. Most African countries feel it is not benefiting Africa. But Europe feels it's a good way to be able to ensure that you go, you fight once and it goes across countries. So now registration, I'm just saying it has to be each other. But as a small businesses or SME, you might not be able to look at the multilateral system in place, or maybe Geneva, as we know, GI is part of intellectual property. We don't have a law, so we can't even talk about it. Knowledge, traditional knowledge is part of it. Just recently, they just passed, and there's still a lot of work to be done. So, I'm always saying in registration, you look at the two parties involved. Most times it's two parties. However, there's also a third party that's involved in the registration level. When a government sees intellectual property as a development tool, and this is a very critical area that we've not talked about it well, really. And how do we use intellectual property as a development tool? In one swing, it's a protectionist tool, to protect someone's innovation, someone's idea. It's a private right. In another swing is a communal right and a national interest. So a government invests in you registering your IP. And who owns the outcome? You own it, but indirectly the government owns it. So I'm saying this because Nigeria or Africa has to start seeing this from that perspective. So we must support our filing from a registration with the prospect that, as a matter of fact, if we want to use IP as a development tool, government should make filing for Nigerian businesses free, just the way they made business name registration free, and pay lawyers to do this work. But they will not see that way because they have not understand the three cases that goes into it. I'll give us an example. China has a hub where they gave 1 million RMB, that is China currency, to every graduate that set up in that hub. 1 million to be able to protect their products from day one, and as well as protect their inventions and everything. What that translated to, right? What that translated to is the revolution we currently have in the digital system, i.e. WeChat. China doesn't use this our WhatsApp we use here. China has its own WeChat. That's one of everything now. Nobody won't carry cash. They do everything on WeChat. Transactions goes in and out. And yeah, things have come. Yesterday I was watching a video and I saw that there's a software now where if you have a child, you can connect your child and monitor your child's system, the phone using where he goes to, where the time he spent on YouTube, the time he spent on Facebook, because people know that this thing evolving. We're in a digital age with AI and the rest of it, where technology is advancing. So you can't deny children that no, you can't use your phone like those days where you say you can't watch TV from 4 o'clock. But what is African government doing to ensure we key into that from a business perspective and from lawyer perspective? So lawyers have to up their game in terms of registration. So now, because I can talk, time is fast spent. Let me move. So my conclusion in registration is two parts. You register and you must weigh it before you register as a business person. Is it giving me the number? Do I need to invest in this to register? Because an average registration will cost about 170,000. Do I invest in my business to grow? And if I do that, I must put in some things to make it happen. On that part of lawyers, when you register a business, and as well as you can also be a business advisor to these people that you register with, you don't then register and let them then go. So now let's move into the aspect of infringement. We infringe on whose right? We have people that sometimes when you see someone using your song, it's just like in church. Someone was saying the other day, how can someone sing and the person is singing in church? And they always saw these people's songs have gone viral. And say the person is okay. That person singing on that person's song, on that copyright and rest of it. It's not really infringement. That is who we are as a people. We share what we have. So we should look at this infringement carefully and not use this as the Western uses. Western are excluded people. We are communal people. So sometimes when someone uses your product or services, in quote, illegally, without your consent, just go with that. So boy, use my this thing. Now my color you use. Okay, what do you want to do? Most time people agree and say, okay, is that you? I didn't even know. Let's do some. Okay, this is strategy. Let's move. Okay, I'll give you give me 1% of it. 1% that I'm going to court and lawyers and judges. Sometimes lack of understanding will put everybody in trouble, make everybody criminal, and people don't move forward. So infringement in African context has to be put into perspective, really. We have to contextualize this most time. As we move as lawyers, as we move as people, contextualize not every battle you fight. And that's why in order to fight this battle, and again, our business support association have not also, mainstream intellectual property infringement. So I've said this thing several times. I had a call from the Scotch whiskey makers from Scotland, their lawyer. And they have some lawyers around in Nigeria. We haven't chat with them. He was, I've been to Nigeria. After everything, he told me, this is the original Scotch whiskey. If you see any Scotch, just tell me. Then, and I will take it off from there. I said, how do we take it off from there? They say, because Nigeria is filled with a lot of infringed fake product and rest of it. But we have different brand. And, you know, so I then realized that Scotch Whisky has an association, so they don't fight infringement individually. The association fight infringement for them because it's expensive to hire people to follow infringement. Like, so country like Nigeria is not part of a lot of multilateral system, and a lot of things are not still digitalized. So they have people, lawyers that they station, like 3 lawyers, they pay them year in year, and they monitor the stuff. So in terms of infringement, if small business want to start chasing people in a Alaba market or something, they infringe your product when you've not marketed. You know, you don't. It saps energy. So look at it from another perspective, or join an association and promote that idea within the association to ensure that your product is fought for and protected at that level. So because you pay your dues. So that's an easy way to manage your infringement. So one is through maybe paddy, whoever stole your right to be able to benefit from it, or secondly, because it's a practical terms, because we are going to a real world. So it's not every time you fight. It's not every time because you're a business person that oh, party to fight. Bring him the numbers, then you can be able to fight. Even Dangote, people are standing with Dangote name. How many people has he got to sue or to do this? But if we start looking at it from that, fight, infringe, enforce, then it becomes an issue. So enforcement comes in now. Who is to enforce our rights? You to enforce the right as a small business. That is where government comes. That's why the community comes. So I'm saying this, let's situate our conversation in IP so that we start also mainstreaming it. Currently, China is rewriting the IP multilateral system, whether we like it or not. You know, China is now in the verge of filing and taking control of the current digital economy revolution taking place from AI and rest of it. So every of this stuff is being protected from China. So China is taking advantage of these to protect their stuff. So as an emerging economy, what we should be concerned about is about us increasing the number of our products before we start looking at the issue of serious enforcement. And if our government then starts taking the IP serious and development too, they should be able to enforce on our behalf. And not enforce our behalf domestically, even continentally, and as well as multilateral system. And the good part is this, I don't know how many of us have taken time, and our appeal to us to, in our lesson, let's look at the AFCLT IP protocol. It's important we then start going into a step further to start looking at why we are not part of the multilateral system. There is also AFCLT protocol that will end up becoming the protocol that will override every protocol, every agreement when it comes to regional level. So what do we know about that? What is the contribution we can make into that agreement, even as the analysis is being put in place right now? So in conclusion, IP, of course, as people have said, is an incentive for innovation. IP, as people have said, is an incentive for job creation. IP, as people have said, is also an asset that you can attract investors to put in. But no investor will come in and say, because I just have a trademark, I'll come and put my money. Why? So it has to go side by side. The number speaks, then investor will be interested. Oh, because my brand is protected. So I make 20 million naira. Okay, fine. So if I give you 100 million naira, we can make this 1 billion in 5 years because your brand is protected. Oh, great. We can then go. So it's both ways that works. It's both ways that work. So IP, so when government sees IP protection and a tool as also an aspect for them to get revenue, they will go all out to protect you, even domestically, to say that, oh, no, you don't abuse this right. And they will also go out to protect one internationally, because also IP, when you then protect it, beyond just the job creation, revenue, it also helps you with integrity and what have you. In conclusion, registration, enforcement, infringement, enforcement, contextualize it in African context. That you save yourself headache. And again, it depends on where you belong. Are you a lawyer or a business person? If you're a lawyer in one area, you might look at it, just go and register, let's go and fight. But as a business person, look at the numbers. Does it worth it? Then you leverage on what's worth it and move. Thank you very much.
Thank you very much, Mr. San Bakano, our soon-to-be professor, San Bakano, for that whole different perspective.
Hussein, let be guided, be guided. The one you people are pushed one into, we are still on it. Now you're moving to professor. Let's be guided. Because that's how people will start. Before you start, you just put one into trouble. Please, Sukurat, warn him for me. Thank you.
All right, thank you very much, Mr. Sand, for that whole perspective on the topic for today. One of the things that really lights me up is when you are telling lawyers to reduce their price. Lawyers, esquires, I know you spent a decade of years in law school and all, but please be easy on us, the startups, as intellectual property can be used as a tool for development and national development and other many benefits. So one of the mentors we didn't have today is Mr. Folarewa Aluko. We're sorry he couldn't join us for today. So quickly, for the next 20 minutes, we'll just be giving our group 1 and group 2 the floor to make their presentation. I know your presentations are very lengthy, so just see how you can summarize. Our dear presenters, summarize everything to be in 10 minutes so that we can take the question and answer session and also some other feedbacks from our mentors. Mr. Marks, Miss Amosa, and every other of our mentors are keeping the chat box very active. Thank you very much for that. Group 1, please be ready to start your presentation now.
Hello, everyone. Can you hear me?
Yes, we can hear you, Juliet.
Yes, we can. I'll share my screen now. Can you see my screen?
Not yet.
No.
No.
Can you see my screen now?
Okay, your screen has come up now. Yeah, we can see it.
Okay. Hello, everyone. My name is Abara Juliet. I'm the presenter for Group 1. So we'll just go straight into the topic, intellectual property registration. We are focusing on national level, international level, and also looking at piracy and anti-counterfeiting. So basically, intellectual property is like the creation of the mind. It comes first as an idea, and then by the time you bring the idea into life, then it is an intellectual property. And then there are various forms they include like invention, brands, designs, artistic work, and so on. So there are four types of intellectual property. We have copyright, trademark, patent, industrial designs, and we also have trade secret. But if we look into trade secret, it may not be classified as intellectual property as much. So basically, we have acts that protect intellectual property. We have the Copyright Patent Act and also Trademark Act. So requirements for copyright registration, based off of the last class, I think one of the mentors mentioned that copyright is automatic, and even today mentioned that copyright is automatic. So upon the creation of the work by the creative, copyright is the creative in creation is protected by copyright. So basically, you need the particulars of the work. You need the particulars of the work, that is the type of work, title of the work, year of the work, and so many other information that you can provide about the work. Then you need the particulars of the author, that's the author's first name and last name. Moving on to trademark, is a distinctive sign or mark that's associated with goods, but when it's associated to services, in some jurisdiction, it is service marks. Then we need requirements for trademark registration. You need the name, address, contact details, and so on. Duration for trademark upon registration and issuing of the certificate of registration is 7 years at first. Then consequently upon renewal, it is 14 years. Then copyright is for 5 years, 5 years, then 5 years. Patent, moving on to patent. Patent is an invention that solves a problem. It can be a new invention and it can be a, sorry, where am I? Let me move on to where am I? It can be a new invention, it can be a development towards pursuant to an old invention. For example, the example given in the last class was big barrel. Like at the point when big barrel came out, it was a new invention. And then after 20 years, it was pushed into the public for other inventors to generate new ideas based off of the idea done by big barrel. And then we have other pens like Lucky and every other pen that was like originated from, that had their invention from big barrel. Then industrial requirements for patent registration, applicant's full name, address, description of the relevant invention, and so on. Then we have industrial design. This is like the physical, like what you can see about a particular product, like the structure. For example, we can use Coca-Cola bottle, like the shape of Coca-Cola bottle, the shape of Fanta pet bottle. It is an industrial design that is unique to Coca-Cola and unique to Fanta. So look at the regional level. I was reading this regional level, but it was not so clarified to me. But after today's class, I'm able to place a distinction between national level and regional level. National level is at a particular jurisdiction, like you can register your patent in Nigeria, you can register your patent or your trademark in South Africa. But at the regional level, there are like organizations that you can easily go to and like register the trademark there so that it can be registered to all countries that are part of that organization. For example, ARIPO. If you register your patent in ARIPO, it can relate to all other countries that are parts of ARIPO. And so have other associations such as EUIPO, and so on. At the international level, it's more complex because there are so many treaties that you need to sign. And so, but WIPO is an organization, World Health Intellectual Property Organization, that is like responsible for registering intellectual properties. Moving on to IP infringement, we have to establish that there must be an IP in existence for there to be an infringement. If your IP has not been registered and it has been used, it is passing off. But if it has been registered and it is used without being licensed, then it is infringement. And if there's different forms of infringement, we have piracy, cyber squatting, and so on. Piracy is the unauthorized use or reproduction of another person's work. And then there are so many laws. Piracy can be seen as a crime according to Section 46 of the Economic and Financial Crimes Commission, and so many other laws that prohibit such. Types of piracy, we have digital piracy, software piracy, counterfeiting. Counterfeiting is relating to products. It's more relating to products than software designs and so on. Like when you see inferior goods of a particular product, for example, like toothpaste, you can see like close up. If like you just use the product and see that it is a counterfeit goods. So anti-counterfeiting is the practice of applying overt and covert acts for the protection of a particular product. For example, now you can change the packaging, you can put a kind of inscription that shows that that particular goods is the authentic goods, and so many other ways to show that the goods are authentic and a form of anti-counterfeiting. So there are so many case studies here, and the World Health Organization it is estimated that about 10% of drugs available worldwide may be counterfeits, according to World Custom Organization, and so many other case studies that I can see on the screen. So I'm working on my time, and thank you all for listening to me. Thank you very much.
Thank you.
Thank you.
Juliet Abara, thank you very much for that wonderful presentation on behalf of Group 1. I know the slides and the research and everything done to make that presentation in place is done by the whole Group 1. So well done, the whole Group 1 member. Let's have Group 2. I would leave the comments for the presentation to our mentors after the Group 2 presentation. So Group 2, please, it's over to you. Do we have our Group 2 presenter on the call? If the presenter is slow, please, backup presenter, you can jump in ASAP.
Yes. Good evening, everyone.
Good evening.
Okay.
Okay. My name is Ifechukwu Beiwunam. I'm the backup presenter for Group 2, and I'll be sharing my screen now. Um,
Backup presenter, I'm sharing the screen on your behalf, so just continue. The screen is up.
Okay. Okay, thank you. I was trying to share it, but it wasn't working. So our topic is intellectual property enforcement. And okay, we are going to start with what intellectual property enforcement is all about. Intellectual property enforcement basically involves the legal steps or actions that may be taken to protect intellectual property rights. And these intellectual property rights have been mentioned over and over again during our classes, like copyright, patent, industrial designs, and trademarks. And it is not enough to have these rights. It is important that these rights are protected, and they can be protected by intellectual property by enforcing these rights. And we have the importance of intellectual property enforcement. And it is important for so many reasons: to prevent infringement, to prevent unauthorized use by infringers, and to ensure that when these rights are infringed upon, that there is compensation, there is adequate remedy for the rights holder. Okay, and the preservation of validity, legal validity, like serving as a notice to other people to not infringe on your rights. Okay, we're going to be moving over to how to enforce intellectual property rights. So intellectual property rights, basically, I think the first step is usually done through litigation. Yes, it's usually done through litigation, but like And generally, the first step is to hire, as a right holder, is to hire a lawyer and to send a cease and desist letter to anybody, the infringer, the person who has, infringed upon your intellectual property rights. And if this is not adhered to, if the person does not adhere to the cease and desist letter, other means may now be sought, may now be taken, like litigation, instituting either a criminal action in court or a civil action in court. So, please, can we move over to the next slide? Yes. Okay, intellectual property enforcement. We've said criminal action, instituting a criminal action in court or a civil action in court or alternative dispute resolution. In the case of copyrights, it is provided for in sections 46 of the Copyright Act of 2022 and section 67 of the Trademarks Act. And Patents and Designs Act takes care of the enforcement of patents and industrial designs. And okay, when these actions are brought to court, there are various remedies that may be available to the right holder, be it a criminal action or a civil action. And there are the remedies available for the infringement of intellectual property when it is taken to court. Usually the court may make an order of injunction, or may award damages, may order for the inspection and seizure of infringing items or articles, an account of profits in the case where the infringer has, made sufficient profits from infringing on a person's intellectual property rights, and an order to deliver up infringing articles. An injunction is basically an order of the court compelling a person to restrain from doing something or compelling a person to do something. And another form of injunction that is very, very popular in intellectual property is the anti-pillar injunction, where if there is a grave danger of, evidence, tampering with evidence, the courts may make an order to allow the right holder to enter into the infringer's premises to, secure the infringing items or articles or the evidence. Okay, and in an order for inspection and seizure, an order authorizing the applicant to enter the premises at any time, accompanied by a police officer not below rank, to seize infringing items. An award for damages. An award for damages may be made based on the court's criteria for measuring damages, which may depend on how the flagrancy of the infringement and the profits that were acquired or they were made by the person who infringed on the intellectual property rights. And an account of profits to prevent unjust enrichment it is based on the equitable principle of prevention of unjust enrichment. And the court may order the infringer to account for profits he has made from infringing on the intellectual property rights and to award them to, and maybe, compensate, given as damages to the right holder. We've talked about alternative dispute resolution as an alternative to litigation, where the dispute or where the matter may be submitted to either an arbitral tribunal or a mediator. Yes. Okay. I don't see okay, I think there are some cases
on this, but they are not in the slides. I think because of time, we'll end this here. We've talked about what intellectual property enforcement is, the methods of enforcement, and what remedy may be available to a right holder when these rights are infringed upon. So thank you. I think we'll end this here because of time.
All right, thank you very much, presenter, backup presenter for coming up when the main presenter for the day is now available. Quickly, I would call on our mentors to make their comments on the presentation for today, as immediately after that, we'll be taking question and answer. Ms. Nirvana Talk, please, if you're still on the call, we just need a brief comment before we go to the question and answer session from you. Nirvana Talk, are you on the call? Okay, Mr. Marks can go next. Mr. Marks, do we still have you on the call? I can see Mr. Marks on the call. Okay, Mr. Sand Bakalu. Any comments? Okay. Ms. Shukrat Amosa. Please, let's confirm. Can we all hear me? I can't get any feedback from our mentors.
Yes, we can hear you.
Yeah, we can hear you. Loud and clear.
Mr. Mark said that he just needs 5 minutes.
Yeah. I can see Mr. Mark's message. So, Miss Nirvana, Miss Rita, Miss Shukra Amosa, please, anyone can just come up with any comments, any corrections. You can just please draw before we move on. Okay. I can't see Miss Rita on the call. I think we've lost Miss Rita for today. So we
Okay,
okay.
yeah. Good evening.
Good evening.
I think my feedback basically is, I think it was Juliet that presented. I like that her presentation was well detailed, and she actually spoke like she knew what she was talking about, especially when she gave examples and cited some stats and cases and all of that. For group 2, I don't think there's a bit of coordination, and the backup presenter didn't seem like someone that actually knew what she was talking about, but everyone did a good job. I think based on what everyone has presented, everyone has done their best based on their level of knowledge at the moment. But I also expected that we should have, done like a little bit more research in terms of our area of topic, and also given the fact that the presentation is also time bound. So I guess that's it from me.
Okay, thank you very much, Ms. Rita, for that comment on the presentation. I believe our mentees would take note of that and improve more on the future presentation that they'll be making. Do you have any other mentor, Ms. Shukrat? If Mr. Max is on the call now, you can also have him or Mr. Sand.
Okay, let me just comment really. Just as what Dr. Rita have observed and also mentioned, I was wondering, I'm tempted to ask, how many times did the mentors, mentees, how many times do they meet? Do they meet at all? Do you have a structured time they meet and to turn this on? And do they do a dry run? Because it's important you take this opportunity very serious. When we are starting up, we did learning by doing. And that made us make a lot of mistakes and not even have a focus. And that means that we wasted a lot of time that will have channeled into being focused. So you take this serious. If you're not serious about it, look around us as a people. And I always make this example, look around us. There's a lot of ill-informed decisions being made affecting everyone's life economically. So do you want to be in that situation? Because if you're already a graduate, you should start taking some level of responsibility and seriousness in what you do. I cannot imagine that you are making a PowerPoint. I see some of the presentation, and I'm wondering, do they really went through university? I'm sorry to say, because your presentations has to be top notch. If it's people like us that we've done presentation, over and over, we can mess around with it, but we will expect people as young people to put in your best, use the best technology. So now, if you don't meet regularly and you don't delegate, then you have this. So you have an opportunity to go and represent a client in court and speaking to lawyers, and you are not prepared. It will translate. It doesn't matter if you say, when I get there, I will pass it. No, if you don't do it now, whoever is giving responsibility in small thing will deliver in big thing. And I will end it with this word again, saying, well done for even trying to make this effort, but you can do more to be better. Articulate your point, speak with confidence, understand it. You can only speak in confidence when you have done your background work. Discuss among yourself. Forget about social media. Look at this and defy your gratification of social media will always be there. But whenever you have opportunity to present things among 2-3 people, put out your best. That is my abolition. That is my word to you. But again, congratulations for being part of this initiative. You're on the right track, but we need more from you. Whoever, the reward for hard work is more work. If Nigeria is still the poverty capital of the world, that means we can never take anything for granted or joke with it. We must be serious like any other thing. Have you ever seen a Chinese young people? I schooled with Chinese. I was the only Black person in 99% class of Chinese. And I see them step into class. They can't speak a word in English. Within 3 months, they can articulate, express, write in English. That is not just coming and sitting down doing some stuff. And you see them when they do PowerPoint presentation, you marvel. And these are people that tell you that Jesus Christ is bread, because that is none of their business. Oh, well, thank you very much. We hope to see you guys more organized next time. And I wish you, as we go through this journey, to become out on the other side better off, polished, smart, and ready to rule and govern us as a people, Nigeria and Africa, and represent a Black race. Thank you. Bye-bye for now.
Thank you very much, Mr. Sand, for that very, very intensive life advice and also advice on improvement to our mentees. As Mr. Sand asked from the beginning of his comment, if our mentees meet. So the answer to that is, yeah, our mentee have like a group like the group one, they have like a general group where all the group one members are. The group two, they also have a general group where all the group two members are, where they can talk anytime. You can, just like the way normal WhatsApp group is, you can send message in anytime. You can interact with your group member. They can jump on calls, audio calls, video calls, while they are doing their research and everything, putting up the PowerPoint presentation. So we can all do much more better. We can improve our PowerPoint presentation. We can make in-depth research, know what we are talking about, and improve the confidence while speaking to the topic of presentation. So I don't know if any other mentor have any comments before we jump into question and answer session for today. We're still waiting for Mr. Max and Ms. Shukrat and Musa. While you're waiting for them, please, any mentee that has any question for our mentors, either of our mentors on the call, please just raise your hand so I will call on you to ask your question. Before I move on to some of the questions on the chat box. Although some of the questions have been answered, so we'll just take them briefly.
Your mic is off.
I'm sorry. Thank you very much for correcting me. I'm still encouraging anyone with questions, don't let any questions be in your mind and you just be wondering. Just ask. No question is stupid. Just ask your question. Our mentors would answer your question and enlighten you more on the topic for today.
So I had a question.
Okay, you can go ahead, please.
Okay, during Mr. Sen's presentation, he made mention of a protocol. It initiated with like AO something something protocol, but I didn't get the entire name. I don't know if he could reiterate that protocol title.
Okay. So I was referring to protocol on AFCFTA. And so the AFCFTA agreement, which is African Continental Free Trade Area Agreement, is an initiative of the AU to harmonize and bring together the African market. But within the agreement, so there are different protocols that would give that legal document the ability to be effective and address and promote trade across Africa. So IP protocol is one of them. We have also the digital trade protocol. We have the protocol on goods and services. We have the protocol of free movement of person. So we have the protocol in competition. We also have the protocol, I think, on gender and women. So AFCFTA Intellectual Property Protocol is what I was referring to. And I think we have to take a session on that. And why it's already out, I think, because I have a copy. Madam, our leader, I think she also have a copy. If she doesn't have a copy, she can boss me. I will share the copy with her. I think we have to take a session on that to be able to start seeing it the way it is, why the analysis is being worked on, because when the analysis is being worked on, the analysis will give us a more deeper understanding and reflecting some of the things that the agreement itself has said. From, for example, most vulnerable nation component, how do we address that? The aspect of geographical indication, how do we address that? So the analysis will speak to that. Thank you. I hope I have answered your question.
Thank you very much, Mr. Sand. And just a quick addition, the AFCFTA, African Continental Free Trade Area, geographical indication and genetic resources are two topics that we'll still be touching in the course of the Jiipcc mentorship and internship program. So Mr. Sand Mbakanu is one of our seasoned mentors that would also be expecting on those classes. So we look forward to joining those classes in the future and learning more about AFCFTA and other related topics. So any other question, please, you can hit it up. I can see that most of the questions, if not all, on the chat box has already been answered through text by our mentors. So we don't really have much questions. And one of the things that Jiipcc Hammer takes very serious is questions from our mentees to our mentors. So just don't let anything be on your mind that you just think. Don't just think. It's always better to know and be sure. So whatever you want to ask, please ask. As we all know, you guys didn't send in questions for our mentors before the class, which we were supposed to do. Emma Brown, you can also take the next question.
Yeah, sorry. I had one question from last week, whereby it was just like to any mentor who wanted to respond. I asked if, in their opinion, they felt the trademark switch of Twitter to X, how that impacted like the marketability of Twitter as an application, and like why the owners actually made that switch in the first place. I wanted to know like their opinion on the impact of their consumers on that switch.
If I
Any
can
of our
speak, if there's
can go with
another,
that.
if another mentor is on online, they can speak. But I can just give a quick intervention. For me, it's so annoying. You see, this is some of the things that as a government you have to step in. People cannot be above the law. The interests of consumers are important. For switching from Twitter to X, the consumers' interests were not considered. That's why a lot of people, me, I still call it Twitter. I still feel it's just out of place, really. And because he has money, so he bought even Twitter in the first place because he feels he can buy over anything for a political interest. And so he's forcing things down our throat, saying, what can you do? So which means that the competition authority would have stepped in. But again, they didn't really infringe. I'm not too a legal person, so I might not be speaking from a legal perspective. I'm only speaking from most times a consumer perspective that has used Twitter for years, and as well as someone has also benefited from it as we still call it Twitter X. What is X? So are you going to trademark X as it stands? And I think he can, because he has the money. It's about where he has the money. So he just tells you that the system, the capitalist system, is something that we also have to question as a people. So when I talk about African, we coming together to address some certain things, these are some of the stuff. You can't start up a brand. One will say, did they expose anyone to danger? Did changing of the name harm anyone psychologically, emotionally? No, not really. But our love for Twitter, it took it away just like that. What a shame. That is my comment.
Okay, thank you. Thank you, Mr. Sen.
But what do you think yourself? What do you think yourself about that change? Do you think it was a sensible thing to, from your perspective? Because this is your generation.
Yeah. Personally, I don't really understand what motivated the owner to actually make that switch. When I researched it, it just said that he had a personal love for the letter X. But then if we were to like look at the, I guess, cultural or the customary activities that have been going on Twitter, like there has been like very excessive sharing of like pornographic content.
Absolutely.
Distasteful things like that. So you look at such practices and then all of a sudden it goes from Twitter to X. It's a little bit confusing. Like, what was your intention when you made that switch? So I don't know. I don't really support. I feel like Twitter is a better handle, in my opinion. I also shared that opinion with you.
Absolutely. That is it. So now there are a lot of things that have been free speech should not be free. It's also a barrier to other people. So how far do you want to push free speech? Although, as I said in my statement, that when there is challenge, invention emerge. So there are parents now that can monitor whatever a child goes to. But at the same time, those that don't have the opportunity of having parents that monitor, because that pornography everywhere is a distasteful thing. But he doesn't care. He says it's a free speech. Just give me the money and you do whatever you want. But it should not be so. So government and no African government has even stepped up to speak to that.
Yeah.
But we speak to that when it comes to political. We speak to that when they say the president cannot tweet. Unlike previous when it's tweet, when it was Twitter. So let's be mindful, even as we emerge, to consider this stuff. Africa is a continent of morality. We have our culture. Even when, forget about what is going on in Nigeria, we should be that ambassador of saying integrity matters, how you do business matters. And the same way how we carry ourselves. And when we carry ourselves, like we can rewrite the narrative to represent who we truly are, not being influenced by someone that feels he can shoot one plane up in the sky and make billions of dollars and just force things down our throat, not minding how we feel about it. Distasteful.
Yes. Thank you, Mr.
Thank you very much.
Thank you very much, Mr. Sand, and also Imabong for bringing up that question. My 2 cents of view on that aspect is that I think from his own, what I think he might be thinking is that when he bought the company as Twitter, maybe because he wants to show maybe his dominance or something, he has to like change the previous name to just create something new and give it to the X. But although from customers' perspective, I know that most of us still call it Twitter. Most of us prefer Twitter. Yeah, that's just my 2 cents of contribution on that. I don't know if anyone also have any contribution to say or anything about Twitter and X. Okay, and Mr. San Umba has also been talking about the use of technology to monitor what your kids are doing. I encourage everyone to embrace technology. Just from the AI, the recent AI, the ChatGPT and Gemini, from the units used of your phone, just from your phone to your laptop, for work purposes, for personal purposes, we should all be very careful. We should all be very informed on how to use these technologies. The recent updates, what the updates means, because I know here in Africa we have this behavior of not reading what is it called? Privacy, product privacy, or what is it called in data protection? Where we just buy a product and where we just sit down, just all this long privacy policy, and we just click accept all, and we just start using. So I encourage everyone to not be of that kind of behavior. You can always do better by being informed and knowing each and every technology you are using very well. Just like also Miss Nirvana also mentioned about how she was being hacked. So it's first, the responsibility starts from you as a person to protect yourself before you seek out for your bank protection and every other platform's protection. Any other question for our mentee before we go for today? It's really an amazing session for me. I'm very excited that we have 5 mentors out of 6. We've learned so much from our mentors, and I look forward to moderating other sessions and also learning more. Mentees, please, I still expect most of our mentees to ask questions. Please, we still have a few more minutes to go.
Yes, good evening, sir. I have a question, sir.
Okay, you can go ahead.
Yes, my question has to do with regional registration of intellectual property. So throughout our mentorship programs, in the previous programs, it was mentioned that Nigeria is no longer a member of ARIPO nor IPO or IP. Now, if someone who has intellectual property to protect in the regional countries of Africa, so what are the steps for the person to take in order to get the intellectual property protected at the regional level in Africa? That's my first question, sir.
Okay, thank you very much for that question. Any other mentor on the call can take the question before Mr. Sand. I know Mr. Sand is with us. Miss Amosa, Mr. Max, if you're on the call, please, you can. Also, Miss Nirvana talk. I can see she's on the call, but we don't get any response from her. Okay, let's just move forward to. Let's move forward to Mr. Sand. Please, Mr. Sand. I believe you heard the question.
Okay, so Nigeria has never been a member of ARIPO. Neither have we ever been a member of OAPI. So if you have an intellectual property you want to register at African level, you go that. So there are lawyers, just like on the platform we have, where people will say, oh, do you have any lawyer in XY country? So I have, then they will go and register it. So you go individually to those countries and do your filing. So you don't go through ARIPO. Even if you are going to go through ARIPO, use ARIPO lawyer to go through that stuff. But again, Nigeria has an observation status with our ARIPO, but we have never been a member. And so we're hoping that this AFCFTA will help us also to scale that up to be able to file across other regions or other African countries. So you go individually to those countries to do your filing. That's my
All right, thank you very much, Mr. Sand. I hope that answered your question. The mentee that asked the question. And do you have, I think you also have any other question you can ask, please.
Another question. So another question I have is that, so let's say, for instance, now I advise someone to protect their intellectual property. Now, it was mentioned during the discussions by our mentors, it's not only advising someone to protect their intellectual property, so we still need to tell them the strategies they will devise in order to maximize profits from the protection of the intellectual property. So how can we go about the strategies to tell them to devise in order to maximize profits from the intellectual property after the registration?
So my response to that really is straightforward. Build your own capacity. Work with people that have done it. So I don't know if you're attached with a law firm now, so branding might not be your legal stuff, but you can encourage them to get a branding expert, because registering a product, IP product, you should not just leave just like that. As you move up, you can start doing your CSRO documentation, knowing that you have standards. Let your standard be standard. You don't have yellow today, tomorrow you have brown. It has to be standard. That is business advisory now. So in terms of also having your book in place, having your policy documents in place, marketing it, networking, these are things that you can participate in trade fairs, exhibition. These are the added stuff you can get him or her to do when you register that brand. Give them ideas. So you go to places, you hear people do things that are promoting business, you connect them, do publicity, social media boosting. These are things that will make the brand know, be heard and make money. So registration, encourage them really. What we are just saying, don't just take their money, register them and just say bye-bye. The next time they will hear from you, they will always be want to call you. Reach out to them, speak to them, because sometimes they might be overwhelmed by what they are going through. However, if we are currently working with a law firm and they specialize in IP, most times one law firm always specialize in high level IP. But if they even specialize in high level, look at them, how are they engaging with our client? Then you can learn from there. But you can expose yourself to learning. WIPO has a lot of courses on this. ITC also have a lot of courses on this. You learn, you can then see how you can then practicalize it in real time. Because what we learn in universities in Nigeria is most time we just think it's just classroom textbook. No, what we learn is to be able to put it in real time work. So expose yourself to learning, engage with your clients, be their mentor, their business mentor, literally. That is the only way you can help them make money. Thank you.
All right, thank you very much, Mr. Sand, for answering the question. We have Mr. Max back on the call. Mr. Max, please, right from the comments on our mentee's presentation to the questions you answered on the chat box, we'd like you to just go through everything briefly and give us any last words. We're also expecting any more questions for our mentees before we end the session for today. Mr. Max, over to you.
Okay, thank you. So can you hear me now?
Yes, we can hear you.
My apologies. I'm at the Bar Association, the MD Abuja branch monthly meeting. So that was why I was away from the meeting for a while. But I was still able to listen to the presentations, maybe not very fully. But I must commend the mentees and for at least quite a thorough job done on the different areas. I think particularly on I think it was the group 3 or so, the third group. Okay, the third group that presented, there were 2 things I saw about their presentation, which I really commended, because I was happy that they took their time to really look closely at the issue of infringement, But I don't know if I heard them well, but there was one point that I didn't make when I spoke earlier that I think is important to make now. That there are certain IP issues that are embedded in contractual disputes where it might become a little bit tricky. So a classic example is the case of franchising. Franchising itself, or even other forms of IP licensing, but particularly franchising, is a contractual agreement. But at the root of that contractual agreement are IP rights, because part of what the franchisor, the owner of the franchise, is doing essentially is licensing the franchisee his, a basket of his IP rights, including his trademark, his trade dress, copyright, and patents and all of that. So, a classic example, of course, would be the fast food joint, McDonald's, KFC, and the rest of them. So, what they give you essentially is a full bouquet of their IP rights to deploy in your own business and run your business according to a format given to you by the franchise. So if a dispute arises in that situation, it becomes a little bit tricky to know exactly how to resolve it, because at the heart of it are IP issues, but then on the periphery, on the surface of it, it's a contractual issue. So in those kinds of situations, also you have to really be careful how you go about resolving the dispute. I believe it was Rita who talked extensively. No, I think it was Amosa who spoke about the WIPO's mediation and application and mediation center, AMC, which is also a very good tool to use in resolving disputes. So in my initial presentation, I spoke about litigation. Litigation sometimes is necessary, but best practice and international practice generally encourages arbitration and mediation currently over litigation of IP disputes, because one of the advantages you have with arbitration and mediation is that you have an expert in the subject sit as quote unquote the judge over your case, unlike our regular judges who are not exactly all trained in IP. And the same judge, for instance, at the Federal High Court in Nigeria handles a case of armed robbery, maybe not armed robbery, but a criminal case, handles a maritime case, handles a fundamental rights case, handles a case of narcotics, and then the same person is taking over an IT case. So there's no specialization in the judges. So one of the advantages of using a center like the WIPO AMC is that you get specialists in the area come to resolve your dispute. So like I mentioned, franchising, for instance, is very complicated. If you hand it over to simply a judge who is best in contractual matters, he will not appreciate the underlying IP issues, and you might end up with a decision that does not do justice to the IP problems that arose. So I just wanted to add that as my initial comment on litigation, that indeed litigation might be necessary and is necessary, but if you can avoid litigation, it is better you avoid litigation and use any of the arbitration or mediation to resolve your IP dispute. So then that is for my general comments. I don't need any specific questions you wanted me to answer. I could just touch on them briefly as well. So then, are there any specific questions that were directed to me? I apologize, I didn't look at the chat, so I'm not too sure if there are any direct questions to me. But if there are any direct questions and any mentor wants to ask, then I can provide the direct answer immediately.
Oh, thank you, sir. I think the mediator briefly lost his network, but most of the questions were already responded to in chat.
Okay.
Yes.
Thank you. So I guess another question. Okay, so since we lost our host, okay, maybe while we wait for him to come back, I think I saw a few very interesting questions in the chat as well. So somebody was asking about the laws that regulate registration of IP. So like I mentioned in the chat, and maybe I'll just emphasize that the laws themselves specify clearly what the registration requirements are and what registration and what rights are eligible to be registered or protected under the Act. But like I mentioned, you have to note that beyond the laws themselves, there will be regulations and there will also be guidance notes sometimes issued by the IP registries, but there are also practice issues. So sometimes some of them are not written. So you might not find anywhere written black and white, for instance, on the issue of registration of logos for trademark, for instance. Now, it's not anywhere written in Nigerian law in black and white what the extent of protection of a logo is in terms of color, because we do not have any laws regulating color trademarks in Nigeria. But the General Convention internationally, which has also been adopted into Nigeria by convention and practice of the trademark registry, is that if you register your logo in monochrome, that is in black and white, then you are protected for every color representation of that logo. But if you register your logo in a specific color, then you are only protected to the extent of that color. It's a dicey issue, but the understanding here is that your choice of color when you submit the specimen of your logo at the point of registration, in a sense, could work against you or it could work for you. So there are circumstances where you are registering a logo that is very common in that sense. But what could make it distinct for the purpose of registration is the color, the unique color of that logo. So in that case, you want to register it as a color logo. But if you generally want to protect that logo and the logo is really unique, then it's advisable you register it in monochrome, that's in black and white. So like I said, this is not written anywhere in the Trademark Act itself or in the Trademark Regulation, but it's a convention adopted internationally and with the Trademark Registry in Nigeria recognizes and enforces. So these are some of the tools of the trade that are not, you won't find written anywhere in black and white, but by virtue of practice and experience, you get to understand. So I thought to just bring that to your attention.
Thank you, sir.
So if you say that, yeah, thanks.
I think Mr. Dennis is here, but then I had like one question since we're talking about trademarks.
Okay.
According to the TRIPS agreement, it said that a fragrance can constitute as a trademark. I don't know if you could like explain that. I don't understand how a fragrance can distinguish a company from another.
Okay. Yeah, thank you. That's a good question. Yeah, that's a good question. So the idea is this: if you remember what a trademark is, let's pull back the trademark. A trademark is any unique identifier that creates an association between a product and the originator or the enterprise that produces that product. So the idea is that a trademark is what signposts to the world that this product is coming from a particular organization. So the question we have to ask ourselves is that, is it possible for a fragrance to make you know where a product is coming from? Typical example, a bakery. So I have a bakery close to my office, and there are certain times of the day when I pass that bakery, when they're actually baking, there's an aroma all over the street that tells me, oh, they are baking. So if I want to buy fresh bread, for instance, I know the timing, after I perceive that fragrance, 30 minutes after, the bread will be ready. So the idea is that it is possible that fragrance can become an identifier that makes you know this particular pastry or bread comes from this bakery and not from the other. So in that context, it could be registered. But however, under Nigerian law, strictly speaking, you cannot register a fragrance because Nigerian law makes it clear that what you can register as a trademark must have a representation, a graphic representation. So it could be word, it could be a logo, and then the trademark has written a lot of things. It could be a ticket, a signature, and all of that. But there's a requirement that your trademark to be registered in Nigeria must have physical embodiment. That means you must be able to represent it in a graphic manner. So you cannot represent a fragrance in a graphic manner. So there's an interesting EU case where somebody was trying to register a fragrance mark, and part of the requirement under the law at that time was that there must be a graphic representation. So what the person tried to do was to describe what that aroma was like using chemical signals. So it says something like a burnt orange smell, for instance. But the case went up all the way to the EU Court of Justice, and the EU Court of Justice said no, that's not enough to be a graphic representation of that trademark. So things like fragrance, some jurisdictions allow it, but it's not yet mainstream. So the major industry where that's relevant, of course, is perfume. So, I mean, of course, you know that perfumes, the way we recognize perfumes is essentially the fragrance. So in the perfume industry, fragrance mark is still a hot topic, but currently in Nigeria, there's still a lot of difficult stages, even everywhere in the world. Being able to represent that fragrance, but how do you capture it? How will people know what exactly you have protected? Do you drop a sample in the trademark office? And even if you drop a sample, after 5 years, the sample may lose the fragrance. So it's still a conceptually difficult issue when it comes to fragrance mark.
Right. Okay. Thank you, sir.
Yes, thank you so much. Thank you so much, Mr. Max. Thank you so much, Imal Bong, for your question. No, it's not Hussein, it's Dennis. Sorry, I was knocked out for a while. But it's nice to see that the class continued even in the absence of Mr. Hussein. So thank you so much, Mr. Max, and thank you to Imal Bong. All right, so please, I'm sure we are still in our question and answer segments. Do we still have more questions? And in the absence, if there's no question, I think it will be safe for us to call it a day. But do we have any questions from our mentees? Do we have any more questions? Please, you can indicate by raising your hand. You can also indicate by sending. You can also indicate by sending your questions to the chat box. Okay, I haven't noticed any questions so far, nor anyone indicating their need for answers to questions. So in the light of that, I think it's safe for us to call it a night. Thank you so much to our mentors that have stayed with us throughout the session. Thank you to Mr. Max. I can see Miss Nirvana still on the call. Thank you very much, Ma. We really sincerely do appreciate your presence, and to the mentees that have been here through the 2 hours plus session. It has been nice having you guys on call. Thank you to our moderator in absence, Mr. Hussein Mahadi, and to the entire Jiipcc team that puts this class together. So in light of that, I would like to ask that our mentees, please kindly post what you have learned on your social media pages. Do not forget, we'll be regrouping for the next week assignment. So kindly pay attention to the groupings that will be taking place this evening or early tomorrow morning, and make sure to get straight to working on your presentation. Do not forget to reach out to your mentors. Like we've always pointed out, they are free, they are available. Follow them on LinkedIn, tag as many of them as you can in your posts, and always try to reach out to them when you need help or any form of assistance. So good night, everyone. Please, everyone, enjoy the rest of your evening.
All right, thank you.
All right, thank you. Bye-bye.